My name is Norman Younger, and I've got many years' experience in dealing with boardroom disputes. So we're going to take a look at how mediation can be used to resolve these kinds of disagreements. Conflict in the boardroom can lead to deadlock or worse. There'll be a lack of focus on the business itself. Too much time will be spent firefighting in the boardroom. There can even be a breakdown of communication, so everyday matters don't get dealt with. Creativity is held back, strategic decisions don't get taken. The business will tend to drift if the rift in the boardroom or at a senior level is serious enough. Problems fester, decisions are not taken, and bad blood at the top level can spill across the firm and be picked up way down on the factory floor. Senior staff may leave or defect to competitors. Customers may defect if they are concerned for their well-being. Suppliers may become wary of the future and terms may become less favorable. Publicity, if it gets out, could well strangle the business. Ultimately, the business could split or collapse entirely. Traditionally, business disputes go to law. The problem is that lawyers, by their training, are adversarial. It's about finding a winner, sides get taken, and if it makes it to court, is going to be public. By going to law, positions become entrenched, costs escalate quickly, and the fees are open-ended. The conflict will deepen, and there is no end in sight. The legal system is notorious for delays. The outcome is, of course, uncertain because you're dealing with the law and you might end up in front of a judge. It's more likely to destroy the business, and whatever the outcome is, whether you are the winner, inverted commas, or the loser, it will create untold stress in the interim. Mediation is a mechanism for bringing people together to facilitate a conversation. And one of the beauties about it is that you will retain control at all stages of the mediation. It's about ending the conflict, a common search for agreement between the parties. It's quick, it's confidential, it's cost effective, and is time limited. You know how long it's likely to take, and the outcome is risk free because you're not at the mercy of the legal system or even an arbitrator where you have to sign up in advance to be bound by their decision. There is no advance agreement. It only becomes legally binding if the parties can reach an agreement and sign it. It lets everybody move on, and it has a success rate over 80%. It's well worth trying it, even if you're not sure whether it will work and you do intend going on to the legal route. Try mediation first. So, what's the mediation process like? Well, the mediator will be briefed in advance on the basics, and there will be joint sessions with all the parties round the table, and there will be private sessions where the parties talk in strict confidence with the mediator. It's a process which allows things to be said in an appropriate setting and an appropriate manner. Very often people want to get things off their chest, but they feel they can't do it in the boardroom. Mediation is designed to let this take place. You can bring along professional or lay support, for example, an accountant. You can have a lawyer in a room, and nothing wrong with that. You can have a friend, a family member. The process will allow you, the parties, in private sessions to evaluate any offers made by the counterparty or to think about offers they may wish to put forward. It allows them to consider their positions in the light of perhaps hearing things that they may have not heard before. And the possibilities for resolution can be explored in the private sessions. The parties, i.e. you, will provide the solution. There's a lot of give and take may go on, but this is one of the best mechanisms for allowing that. And of course, you are free to leave the mediation at any stage. So let's look at the timings involved in the mediation. Well, the preparation may take a few days in advance. The actual arrangements and logistics will probably take a day or two. The process is typically over within one day. It could even be in a morning or through a single telephone call. The key is that time is used tactically by the mediator to bring the parties together to get things wrapped up quickly. And the agreements can be drawn up very quickly afterwards. And usually from start to finish, you're looking at around a week maximum. And it can, of course, be done much faster. So what are the likely costs? Well, you've got the mediator's fees, either for a full day or a half day. There might be travel expenses for the mediator. Venue hire, very often you'd go to a suite of rooms. You've got the round the table session, and you've got a room each for the parties. You've got time for professional supports, might be an accountant to prepare. Professional attendance, you've got your solicitor might wish to come, needs paid for. At the end, you might wish lawyers to draw up the agreement, that will cost. Typically, the costs are split equally between the parties, though one side could offer to bear the costs. And in a boardroom split where it's the business which is at stake, the business itself could pay for the mediation. Does a mediator require any specific expertise with boardroom disputes? Well, strictly speaking, it's not essential that the mediator has expertise of any discipline they're dealing with. They are facilitators and they are trained how to handle a variety or any situation. Having an outsider brings a fresh perspective and a new approach to the whole disagreement, which is why you have a mediator. General business experience is definitely advantageous, and if there is focused expertise, that will definitely help. So if your mediator has experience in dealing with boardroom issues, shareholder disputes, senior management issues, whatever it is, it definitely allows you to look at things with the input of someone who's got experience, who may have experienced a situation slightly different to yours, or perhaps similar to yours, whatever it is, but will bring a new way of looking at things. And by being a professional, by training, whether it's an accountant, a solicitor, or whatever it might be, if it's any relevance at all, certainly assists in the gravitas and the conduct of the proceedings. So if you'd like to find out how I can help you, please do not hesitate to get in touch. There's my email address, telephone number. I'll even pay for the phone call. Any questions, I'm happy to talk to you without obligation. Thank you for listening.